Greetings everyone. My name is Haya. I am a legal mind and I'm trusting to address every one of you on matters law. And today's episode will be diving into equality and discrimination. As many of you know that many people have been discriminated upon and there have been lack of equality in the setups of employment, setups of learning institutions, and even transport and many other. And that is our interest today, to help you understand areas of discrimination that are prohibited by the Constitution 2010, that you can lodge a complaint in a court of law that has a competent jurisdiction. So welcome. Today, I turn to the cornerstone of the Constitution 2010, equality and freedom from discrimination. So Article 27(1) of the Constitution 2010 clearly states that every person has equal right before the law and equal protection and equal opportunity and even benefits before the law. This provision does not merely declare this article in abstract terms. It constitutionalizes equality as both a right and a principle of governance. From a legal standpoint now, the article archives several things. It establishes formal equality. That is to mean the idea that all persons must be treated alike under the law. Secondly, it advances substantive equality by directing the state to take legislative and policy measures, including affirmative actions, to address historical disadvantages that has always been there. So in other words, Article 27 recognizes the equality is not archived simply in treating everyone the same, but sometimes by treating people differently in order to correct systemic imbalance. This article also provides a comprehensive clause of areas of areas that the Constitution prohibits for discrimination. And these are the areas that I really want to focus on, because these are the areas that people have faced inequality and have been discriminated upon, while they do not know that these are areas that are prohibited by the Constitution, and that at the time you face them, you should lodge a complaint in a court of law that has a competent jurisdiction. Of course, I'm going to mean them. So it prohibits direct or indirect discrimination on grounds including 1. Race, 2. Sex, 3. Pregnancy, marital status, health status, and of course you will even hear someone calling out people on the grounds of their health status. And this has happened in learning institutions, in areas of job. I mean, why would you call someone out of his or her health status? That is an area that is seriously prohibited by the Constitution as an area of discrimination. Secondly, disability. And any other person would want to discriminate upon an individual out of his or her disability. So that is again an area that is seriously prohibited. 2, religion. The second one is religion. The next one is concerns. There is belief that you will now be prohibited in your area of job because you have a belief on something differently differently from the rest. That should be respected and should not be an area of discrimination. We have culture, we have dress, we have language, or birth. Importantly, this list is not closed. Courts have actually read Article 27 broadly, meaning that any form of unjustified differentiation can be tested against the equality principle. Now, in practice, Kenyan courts have had to interpret and apply Article 27 in significant ways. And now, for example, in the case of Center for Rights, Education and Awareness, abbreviation, versus Attorney General, this is a case of 2015. The High Court affirmed that two-third general or two-third principle flows directly from Article 27, and that the state bears the responsibility to implement affirmative action to ensure gender equality is in political representation. And similarly, in the case of Margaret Nyarangi and another versus Board of Governors in Wangagi Secondary School, again a case of 2013, the courts emphasized that discrimination on the basis of pregnancy violated Article 27, underscoring that equality extends to educational opportunities. The decisions that are illustrated in the decisions that are highlighted illustrates that Article 27 is not theoretical, is enforceable, and it provides the legal foundation for addressing social justice and inclusion in Kenya. However, the lived reality reveals persistent challenges. Of course, the discrimination in employment, politics, and access to opportunity remains widespread. The jurisprudential understanding shows the progress, but ultimately, Article 27 now embodies the constitutional vision of a society founded on dignity, inclusivity, and fairness. It challenges us as legal practitioners and as citizens, or as legal minds and citizens, to integrate whether our laws, policies, and daily practices advances or underestimate equality. To put it simple, Article 27 is not just a legal text. It is a constitutional promise and a measure of our democracy. Thank you for staying tuned. Legal Brief Podcast, that is where your home is for legal understanding, constitutionalism, institutionalizing things, contextualizing, problematizing, conceptualizing. And catch me next to our next episode where I will still be talking on areas of gray that people really fail to understand or have difficult time understanding.